A man is arrested. He's questioned for 2 hours. Nobody tells him he has the right to stay silent. He confesses. That confession puts him in prison. 10 years later, that same man is stabbed to death in a bar fight. Police arrest a suspect, and the suspect walks free because he knew the right to stay silent, the right that only existed because of the first man's case. Today, that right gets read to suspects in America, Britain, Australia, even, in a different form, in India. This is Docket Decoded, and this is the case that created the words, "You have the right to remain silent." You've probably heard those words in hundreds of movies, but almost nobody knows they came from a real man, whose own life ended in one of history's greatest legal ironies. His name was Ernesto Miranda, 23 years old, a delivery driver with a history of minor trouble, nothing serious, nothing violent. What happened to him after this case is something Hollywood couldn't have written. In March 1963, an 18-year-old woman in Phoenix told police she'd been kidnapped and assaulted. Days later, officers traced a car matching her description back to Miranda. They brought him in, no warrant, no lawyer in the room, just two detectives, a small interrogation room, and a man who didn't fully understand what he was allowed to say, or refused to say. For 2 hours, they questioned him. He didn't ask for a lawyer. Nobody told him he could have one. He didn't stay silent. Nobody told him he was allowed to. By the end of it, Miranda had signed a confession. Right at the top of the page, in small print, it claimed he understood his rights. He didn't. That confession became the entire case against him. No physical evidence tied him to the crime beyond it, just his own signature on a document he barely understood. He was convicted, sentenced to 20 to 30 years, and his conviction should have ended there. A confession, a sentence, a man forgotten. But one question kept nagging at his lawyers, and eventually, the Supreme Court of the United States. If nobody tells you that you have rights, do you actually have them? So why didn't Miranda know these rights in the first place? At the center of this case are two rights that already existed on paper. The right against self-incrimination, the right to a lawyer. The problem wasn't that these rights didn't exist. The problem was that most people didn't know they had them, and police weren't required to say a word about it. Signal analogy is coming. Here's the simplest way to understand this. Imagine a store has a return policy, a really good one, full refund, no questions asked. But the store never puts up a sign, never tells the customer. The cashier definitely isn't going to bring it up. Technically, the policy exists. Practically, almost nobody uses it, because almost nobody knows it's there. That's exactly what was happening in interrogation rooms across America. The rights were real, but silence about the rights was doing the same job as taking them away. And that's exactly what happened to Ernesto Miranda. 2 hours in a room, 2 real constitutional rights, and zero mention of either one. Rhetorical check-in. Still with me? Good. Because this is where it gets interesting. The Supreme Court didn't just have to decide if Miranda's confession was unfair. They had to decide something much bigger. Should police be legally required to tell you your rights before they ask you a single question? In 1966, by a vote of 5 to 4, the answer was yes. Chief Justice Earl Warren wrote the majority opinion, and he didn't hold back. He wrote that the interrogation environment itself, the isolation, the pressure, the power imbalance, was designed to overwhelm a person's free choice, not through violence, just through silence about what they were entitled to. The court didn't just rule that Miranda's confession was inadmissible. They created something entirely new, a required script. Before any custodial interrogation, police now had to say it, out loud, every time. You have the right to remain silent. Anything you say can be used against you. In a court of law, you have the right to an attorney. But before I tell you what happened to Miranda himself, there's something most true crime channels leave out entirely. The Supreme Court threw out his confession, but Miranda wasn't set free. Prosecutors retried him, this time without the confession, and they still had enough independent evidence to convict him again. Same result. Same sentence. The man who won the case that protects millions of suspects didn't even benefit from it himself. He served his time, was paroled in 1972, and in 1976, in a bar fight in Phoenix, Ernesto Miranda was stabbed to death. Police arrested a suspect. Read him his rights. The suspect exercised the right to remain silent, the exact right created by Miranda's own case. Without a confession, and without enough other evidence, he was released. No one was ever convicted for Miranda's death. The irony wrote itself. So what actually changed because of this case? Every arrest in America, ever since, now includes some version of those words. Not because Congress passed a law, but because the Supreme Court said silence about your rights was its own kind of coercion. It became so embedded in American life that most people can recite part of it from memory, not from a courtroom, but from television. But it's worth asking the harder question. Did it actually protect the person who created it? Miranda himself was convicted twice. His name became a legal shield for millions of strangers, while doing almost nothing for him personally. Some legal scholars argue the warning is now so routine that suspects tune it out entirely, background noise before questioning starts. Others argue it remains the single most important check on police power in the American system. Do you think the Miranda warning still protects people the way it was meant to? Tell me in the comments. I read every one. Now here's where it gets global. Because the idea of warning a suspect exists almost everywhere, but it doesn't sound the same everywhere. In the UK, police read a caution that actually goes further than Miranda. It warns that staying silent can itself be used against you in court if you later rely on something you didn't mention. In Australia, the right to silence exists, but the exact wording and how strongly it's enforced changes state by state. There's no single national script, the way there is in America. And in India, there's no spoken Miranda warning at all. But Article 20 of the Constitution guarantees the same core protection. No one can be compelled to be a witness against themselves. The Supreme Court of India strengthened this further in the Nandini Satpathy case, ruling that this protection applies even outside a courtroom, during police questioning itself. Whether you're questioned in New York, London, Sydney, or Delhi, one simple idea connects them all: rights only matter if people know they have them. I'm Alfie. This was Docket Decoded. Nothing in this video is legal advice. For your rights in your jurisdiction, always consult a qualified attorney. If this case surprised you, the next one will too. Subscribe, and I'll see you there.